and then you gotta click start podcast to actually do that.
Good afternoon, and welcome to the Eganberger and Weiner's 4th webinar of the year. My name is Carmen Wu, and I am one of the advisors here, as many of you already know that. Our firm endeavors to provide our clients with topics that will enhance their knowledge in a variety of financial planning issues, and today our topic is what to expect when serving as a trustee, which will be presented by Autumn McCullough, an estate planning attorney, and I'll be introducing her to you here shortly. But what I want to make sure that you know is that before Autumn is introduced, we will be certainly taking questions at the end. So the session will go for about 45 minutes, and we're going to leave about 15 minutes for questions. So please make sure that you jot down Christy White's email so you can email your questions to her, and then I will present them to Autumn, and Autumn will then answer the questions. All right? Another technical thing that I need to do also is the compliance disclaimer. So if you could please take a moment to read the disclaimer on your screens right now. I'll give you a couple of seconds. I hope some of you are fast readers. Okay, so here I am going to introduce you to Autumn McCullough. I've been working with Autumn for quite a few years now, and Autumn focuses on her practice in the area of estate planning, estate administration, trust administration, guardianship, conservatorship, and fiduciary litigation. She believes in providing value to her clients by remaining approachable and presenting the legal components of a project in a way that is easily understood so that her clients can make informed decisions. So we definitely have that in common with Autumn. And Autumn is licensed to practice law in the Commonwealth of Virginia and in the state of California. And with that, I'm going to go ahead and have Autumn take control of, hold on a second. Take control of the presentation, and she'll go ahead and get started. Autumn?
Okay, sorry. Hello to everyone listening to this seminar. I hope that I provide some good information for you, regardless of whether you are currently acting as a trustee, have been alerted to the fact that you may be named in somebody's documents as a trustee, but I also think from the perspective of in your own planning, when you're thinking about who you might name as a trustee, this will be informative for you to understand a little bit better what's involved so that you can assess the skill sets of someone that you might name in your own documents. So let's get started with that understanding. Acting as a trustee is a tremendous job. So it is an honor. I think that we have moved as a society away from some of the motivations that really colored estate planning previously, where adult children were named mostly in the order of birth. And sometimes that kind of still is appropriate, and those people fill the roles as you would expect them to do. But I think as we get more of an understanding of what the job entails, we can be better decision makers. And if you have been named, you can understand whether this is a good idea for you to take this on or not. Because what you have to understand is that you are taking on this responsibility in addition to your own daily life. So most times when folks are acting as trustees, they still have jobs to do, children to raise, parents perhaps to look after, and they're really taking on, you really should think of acting as a trustee, you are taking on nearly the totality of someone else's life, at least from a financial standpoint. So in a nutshell, your basic responsibilities when you take over as a trustee is you have to make sure that you are aware of all of the assets of the decedent, and you will. There are times when you might be acting as a trustee when the person who named you as trustee is not actually deceased, and that could be because the person is incapacitated or has just gotten overwhelmed and can't take care of their own affairs any longer, and they really just turn everything over to you as their successor trustee. But I am approaching this from that standpoint where you have the original grantor or trustor of a trust who has named you as a successor trustee. So generally speaking, the grantor acts as the initial trustee, and then the successor trustee takes over at one of those points, incapacitation or death. So I'm approaching this entire webinar from that standpoint, successor trustee rather than original trustee, because when you're acting as your own trustee of a trust that you set up, there's very little difference from how you dealt with your assets prior to creating a trust. You just kind of continue on with a little change in title of your accounts. But when it comes to being a successor trustee, now you have this huge responsibility in front of you. So again, you make sure that you understand what all of the assets are, that you've gotten access to them, and that you are essentially doing that grantor or trustor's bidding via the provisions of the trust. And you have to excuse my technical ability. I'm doing my best here to do that. So the biggest thing that I think you need to understand, whether this is within a family or you're doing this for a good friend or business colleague, I'm assuming that that you are not what I would consider a professional trustee, and that would usually be an attorney or a certified public accountant. They will be often serve as professional trustees. I'm assuming they know how to do their jobs, and you all are looking at it from being new to the position. So what you do have to understand is that the dynamics of your relationship with the beneficiary can get challenging. So if you all understand the relationship, it's a triangle of a relationship. You've got that grantor, trustor, the person who set the trust up, yourself as trustee. You've been named as that successor trustee to take over, and you as trustee hold legal title to the assets that are in the trust. So the trust is a thing, the trustee is a person, and it is a person who actually holds legal title. So once you assume the role of trustee, you have legal title to all of these assets. Now, the trust document itself is the agreement by which you are obligated to the beneficiaries. So that's your triangle: trustor, trustee, beneficiaries. The trustee has obligations to the beneficiaries to do what the trustor told them to do in the trust. Now, you have that trust to rely on, and you must, your biggest job is to adhere to the wishes of that grantor, and I can tell you that is not always going to make the beneficiaries happy. So you need to be aware when you step into this that even if you previously had an excellent relationship with this person or people who is the beneficiary, that could very likely change once you take over as trustee, because you have to make some difficult decisions and you have to impart those decisions on the beneficiaries. And you get a lot of emotion involved in this area. You have people who feel that they should not have any strings attached. You have people that want distributions that you are not going to think are appropriate. and you're going to have to navigate those very strong feelings and still do your legal duty, which is to abide by the terms of the trust. So you do keep in mind, remember I started by saying it's an honor to be named as a trustee. Remember that somebody had faith that you're actually going to be good at this job, and try to take comfort in that if you can. But I preface the talk with those issues because the fact of the matter is that even if you have been named in a document as trustee, you cannot be forced to take on that duty. You you may feel a moral obligation to do it. You may have told the grantor when they asked you during their lifetime that you would do it, and so you might feel that moral pull to do it. But from a legal perspective, just because you're named in the document does not mean that you have to serve as trustee. And it could be that at the time that you were named in the document, you were perfectly willing and able to do it, and when it actually comes into play 20, 30 years later, your circumstances have changed, and you may be dealing with your own health issues, you may be dealing with your own family issues that really mean that taking on this huge responsibility of running somebody else's financial life is too much for you at the time. And I can tell you that it'd be much better decision if that's how you feel, if you feel that you're getting overwhelmed, it would be a much better decision for you to decline to serve, or if you're already serving, to go ahead and resign. Because if you take on the job and you don't have the capacity to do it, you're opening yourself up to some personal liability, and you're opening yourself up to really just an overwhelming situation, a lot of headaches. So know that you can decline, and let's talk through a few of the decision points that might cause you to either accept or decline the position when it comes. Firstly, I did say that a lot of times, a lot of my clients, especially these days, so again, I have seen a shift in estate planning to where previously things were put in documentation and never talked about. It was kind of a big secret, and you have a lot of Hollywood moments where there's a big will reading or something like that, and everybody is shocked, and there's all kinds of drama because it's the first time they're learning of it. I find these days that is more rare. Usually there's a little bit more communication that has gone on, and I certainly, and I know a lot of my fellow practitioners, will advise clients to go ahead and speak with their proposed trustees, have the conversation about what it entails, about what expectations that grantor has, what fears they have, what concerns they have. Will tell you about some struggles that they may have with their own children as they were trying to get all that from the grantor. Once they're gone, you can have that resource. So communication is always great. Now, I touched on it a little bit earlier, but be aware that when you're acting as a trustee, you are legally obligated. You have a fiduciary duty to the beneficiaries to act in accordance with the terms and purposes of the trust, and to act in accordance with the Virginia, we're using Virginia as our baseline law here because that's where we are. And the Virginia statutes actually provide, we have a full trust code, and that will tell you your legal obligations when you're serving as a trustee. So you are obligated, I'll just hit some of the highlights, you must make reasonable investments. That doesn't mean if you invest in a fund and it goes down in value that you'll be liable, but it must have been that investment must have been reasonable. So you must act always in good faith. You cannot do things that are self-dealing. So if you happen to have a company and you think it would be great if you could get some additional investment in that company, that's inherently self-dealing. If you're doing that in the capacity of a trustee, using the money from the trust to invest in your own company, that's a longer conversation. It's not that it can never be done, but just be aware that imagine everything you're doing is really being looked at under a microscope, and you want to be sure that you fall on the side of being overcautious when it comes to any of those things that could be seen as self-dealing. What you are not responsible for is anything that happened prior to your tenure. So if the grantor was the original trustee and you are the first successor trustee, those beneficiaries can't say, well, I know that I was supposed to have $1 million inheritance and you're telling me it's only, $250,000 now, this is not right and I'm going to bring an action. Well, if it was run down during the lifetime of that original trustee, the grantor, or even if you're, a successor trustee in line and somebody else has been serving ahead of you, you are not responsible for anything that happened before the day that you took over. So you want to be very sure that you get a good baseline when you first take over. Here, this is what existed when I took over, and anything that happened prior to that, that is not on my watch, and I am not going to be responsible for it. So we're going to touch on a couple of things. This webinar is based on being a trustee and what the office of trusteeship. There is some obvious crossover between a trustee and an executor. Just for your information, an executor is a person who is dealing with the estate under a will. And so this is under the supervision of the probate department of the circuit court in Virginia. And that technical term, executor, only relates to acting under a will. It can sometimes also be called a personal representative, depending on if there was no will, but you are still dealing with the estate through the probate system, you would be a personal representative as opposed to an executor. An executor has actually been named in a will. So I like to try to make that clear because I think it's very confusing to a lot of people what each of these terms actually mean. So although the jobs are similar between an executor or a personal representative and a trustee, they differ greatly in that the trustee is not under current court supervision. The only time a court would come in to look at a trustee's actions would be if the beneficiaries believe that the trustee went outside of their duties or did something that was contrary to the terms or the purpose of the trust. Then they could bring that claim in a court and they would get involved at that point. Oftentimes in planning, you will see that the executor is the same as the trustee, and that's usually because if we've done our job in funding a trust, we hope that all of the assets are over there in the trust, but sometimes either purposefully or unwittingly, a few assets get left outside of the trust. And in that case, we need an executor to run those assets through probate. They'll eventually come back through the trust to be distributed in accordance with the terms of the trust. So we will often, and I generally advise, unless there's some out-of-state issues, that the executor be the same person as the trustee so that you just can deal with really the entire estate, even though you're running a part of it through probate. However, if those people are different, you have a different executor named in the will than you do in the trust, and the executor does something with the probate assets that you had no knowledge of and that went wrong, you as the trustee have no obligation to ensure that the executor does their job as they're supposed to do. So just some things to be aware of. the first things, we're assuming now as we move through the webinar that you have decided to go ahead and take this job. And if you have decided that, then you really should reach out to an estate planning attorney. Usually the person who drafted the documents is going to have some familiarity with the estate, at least as it existed at the time that the documents were drafted, and hopefully some insight into what the grantor was thinking and what some of their goals and purposes were. So it's very good if you have a cheat sheet to be able to reach out to that attorney and get some advice from that attorney. You also want to fairly quickly reach out to a CPA, because you're going to end up with tax issues. Sorry, my technical issues have gone by. It just jumped ahead of me. So you want to make sure that you have your team assembled so that you don't get taken too much by surprise as you get started on this. Probably some of the biggest issues that trustees face is ascertaining where all of the assets are. So as a planner, I'm always thrilled to see that that the person is with a firm like Carmen's, who really has a good idea. Maybe they have the vault system where all of the assets really can be accessed from that dashboard. That is so helpful to a trustee. But if you don't have that, you do have to take pains to go through the decedent's records and try to locate every asset. It can become a years-long endeavor to try and discover some of these outlying assets, but you really are tasked with doing that, and you want to feel comfortable that you've turned over every stone trying to get your arms around the assets. If you've got real estate involved in the estate, you want to make sure that you don't end up causing the home to be uninsured by failing to let the insurer know that it's not currently occupied. So they will most generally have an exclusion if the property is unoccupied for a certain period of time. Anything that happens at that property is not covered under the policy. So you want to take the step and just be sure that you reach out and notify them of that. There usually will be an increase in the premium in that instance, but it's worth it rather than having an issue occur that becomes uncovered. You want to do all of the things that you need to do to cut off further liability. So you want to be able to be getting the mail. Getting the mail redirected to you is often, if you don't have the perfect situation where you have an advisor who knows most everything, the mail is the most common resource that we look to discover assets. So statements will eventually get sent to the decedent, and you can discover assets that way. Also, you are required to pay the debt, so you want to make sure that you get a good handle on bills that are coming in. And often at the end of someone's life, those bills are extensive. So make sure that you have a clear channel for the mail to be getting to you on a timely basis. Car insurance, sort of similar to the home. You want to make sure if you can't immediately distribute the vehicle under the terms of the trust, that you at least get it, make sure that the policy is going to cover it for wherever it's stored at the time. So those are some of the, these got a little bit skipped out of order. Sorry. So I was trying to talk through some of the things that you need to do kind of immediately. You need to contact the Social Security office. If the decedent was a government employee or a veteran, there are often benefits that accrue through those that are separate and aside from Social Security. You want to make sure you notify all of those agencies. You want to make sure that the funeral home instructions have been carried out. This can be, if you believe that you've been named in the document, you do yourself a favor and ask the grantor, soon to be decedent, if you can see the documents while that person is still alive, so that you can get a good grasp on those things that are going to happen almost immediately. I've had clients who, I had a wife whose husband passed away young and very unexpectedly, and she did not know where his documents were located or even that he had them, and she proceeded with funeral arrangements that were contrary to what was indicated in his documents when she eventually found them some months later, and she was distraught. It really played on her that she had not done what her husband indicated he wanted done, and it was irreversible. So I tried to console her, but if you do yourself the favor and try to talk with your loved ones or whomever you think might be naming you, then you'll have a better idea of what's going to be expected of you. So I'm moving now on to the slide that is on your screen, and this is things that after you've taken care of funeral arrangements, you've tried to get the mail redirected, you've tried to marshal the assets, you kind of know what you're doing. Like I say, it'd be a good idea if you have those original documents in hand. You have retained an attorney to help you if you think you're going to need help. And generally, I find if you just will retain professionals early on, it's a little bit of peace of mind. You may not end up using them as much as you think, but just having them there as your resource and your answer person, there will inevitably be things that you have not encountered before, and it's nice to know that you have an immediate person that you can talk to about that. Locating deeds to real property is becoming easier and easier as we get more e-based. So if you can't find actual deeds, it's not the end of the world. You can certainly access them through land records, and again, that's where your attorney advisor is going to come in handy, because they usually will have an immediate ability to access those records without causing you to go down to the courthouse. So we talked a little bit about probating assets that are outside of the trust. Now, if you happen to have a piece of real property, and this happens, if you happen to have a piece of real property that is not in the Commonwealth of Virginia, it's in North Carolina, or it's in Florida, or it's in New York, and it does not get transferred over into the trust via deed during the lifetime of the trustor, you're going to have to probate that piece of real estate in the state in which it sits. Real estate always is governed by the state that it exists in. So you'll be required to actually go to that state and qualify as a personal representative and get that piece of real property dealt with through an out-of-state probate. We've already touched on insurance policies and making sure that you're aware of the debts of the decedent and the ability to pay the debts. It's always a good idea, once you feel like you've marshaled most of this information, to try to anticipate your cash needs and try to determine if there is enough liquidity in the estate already to deal with those immediate concerns, or whether there are assets that are going to need to be sold. You want to do that with the help of most likely a CPA and a financial advisor to tell you which assets make the most sense to sell if it's necessary to sell them. Again, always be thinking about the fact that somebody's looking over your shoulder, those somebody's being beneficiaries, to make sure that they believe that you did everything appropriately. And it would surely be a shame if you sold a family heirloom when you had another easy, ready area of cash that you could have accessed.
Autumn?
Yes.
In this area right here that you're just reviewing, could you give us an idea as to how long it takes to actually to be the trustee and then get all the assets to the beneficiary? How long do you normally have to is there a time frame that you're restricted to, or how long does it normally take to go through this process?
That's a great question, and this is one of the big differences between a trustee and executor and an executor. A trustee is upon the death of the prior trustee, so when it's probably the grantor, immediately authorized to access all of the assets. So really it is institution by institution. So you have the document that shows that you are the successor trustee, and what you're going to need to do to show the institutions that hold the assets, I'm talking mostly now about brokerages and those sorts of things, you're going to show a death certificate. So usually the funeral home is the one who will organize the death certificates for you. You can request as many as you think are necessary, and usually we would recommend somewhere in the range of 10 to 15 because you will have to show original death certificates to several institutions. So those death certificates usually take about 7 to 10 days to reach you. You can, if you feel that it's necessary, you can ask for them to be rushed, and I have had clients that have been successful in getting them in as little as 2 days. But the norm would be more like 7 to 10 days, and then as soon as you have that death certificate in hand, you would essentially go to the institution with the death certificate and the copy of the trust, and hopefully that institution already has the trust on file, but if not, you're going to show it to them, and you just prove to them that you are taking over as trustee pursuant to the terms of the trust, and the reason would be the death of the prior trustee. Now, this is a death situation versus incapacity or overwhelming, in which case the person could resign. So if you have a voluntary resignation, then you would show that written resignation to the institution along with the document, and that's what's going to give you the authority. But as soon as you can prove that to the institution, then you just automatically take over. So this is the big benefit of being a trustee versus being an executor, where you actually have to have your certificate of qualification in hand, as well as the death certificate before you have access to any of the assets. So you can start taking over as far as access is concerned generally within a week to 2 weeks, and then you just methodically go through, and that's an almost impossible question to answer, Carmen, because it's going to depend on the document itself as far as how long is it going to take you to fully complete your job. There may be provisions in there that require assets to be held in trust for a number of years for the beneficiaries to reach certain ages, in which case your job as trustee is going to be continuous throughout that entire time period, and you're going to be just adhering to the terms of the trust and giving those distributions as you see fit.
Okay, thank you.
Mm-hmm. There we go. I have been continuously alluding to the fact that you as the trustee have an obligation to the beneficiaries, and you have the obligation to keep them informed about the administration of the trust. So in a perfect world, your beneficiaries are not breathing down your neck. They're not asking for a tremendous amount of reporting. But even if there is no request, you're obligated to do an annual reporting. And this is just basic. Do you still have control, Carmen? The annual reporting is just standard accounting practices. You need to be showing the beneficiaries that here's the estate that we started with. Here are the expenses that were incurred and I was required to pay, and here's how much is still remaining. And you report that to the beneficiaries because you are that's your accountability between trustee and beneficiary. So you have to give the beneficiaries an opportunity to look into that, and so if they do have any questions or they believe anything incorrect has happened, they have the opportunity to bring that forward immediately. This is probably the thing that trips up most trustees, and that you need to be very aware of, again, when you're thinking about accepting or declining, is that you do have to remember that you're being viewed under a microscope, and you may have to do this with far greater detail than you would your own financial affairs, because the third party is going to be looking at it. This could be, you may be doing this, you may have siblings that are your other, you may be a beneficiary yourself, you're a trustee and a beneficiary, and you have siblings who are also beneficiaries. The dynamic between you, if you are an acting trustee, between you and your siblings often can change, and the daggers will come out. So just make sure that you do your job to keep everything above board and all transparent, and you'll be able to sail through it even with some attacks. I alluded to already the fact that you want to be sure that you're getting any benefits that are due to the decedent, and these can get complex. Some of them are very easy, claiming life insurance, claiming disability income, those sorts of things. I've had a few clients that have quite a lot of difficulty with the disability income, and the amounts can actually get quite large. They may have, the decedent may have stopped receiving benefits, and they shouldn't have, and it would be your obligation to look into that and see if you can get any of those benefits back. Same thing on the private side. There may have been company agreements that require the company to pay amounts to the estate. You want to make sure that you take advantage of all of those and hopefully become aware of all of them as you go through your travels as trustee. Appraisals are another thing that you most likely are going to have to do with your assets. Real estate is quite easy. We can usually use tax assessed value as a pretty good, even though in our area that often is not fair market value, it gets us pretty close, and depending on the issue that you're dealing with, whether you're dealing with a beneficiary complaint or you're dealing with a tax issue, depends on what level of appraisal you would have to get. If it's on real estate, if you're just thinking of it from the IRS perspective, they will accept the assessed value. Beneficiaries are far less likely to accept assessed value as the true value of that asset. So you want to be particularly aware of this. However, if you're dealing with an estate that has the potential to be a taxable estate, and if it's close or you think it could be close, you want to get those appraisals, because you don't want to not file an estate tax return if in fact the tax is due. So it's somewhat fluid whether and the extent to which you need appraisals. It will definitely affect things from a tax perspective, but it can also affect how you deal with your beneficiaries. If there has been a provision in the trust that requires you to make an equal distribution among several people, you do always have the ability to give an asset in kind as opposed to liquidating that asset and giving cash. And if a beneficiary expresses an interest in having that, so usually real estate is a good example, where one of the beneficiaries would like to have the home, for example, and but it's just an equal distribution of all assets, well, then we would need an appraisal of the house so that we could equalize the payments to the other beneficiaries if we give the house to one beneficiary. So that's quite different than if you have a list of tangible personal property that says, the diamond ring goes to my daughter Lisa. That does not necessarily need an appraisal unless it's for tax purposes, because the trust is indicating that she gets that asset regardless of its value. We've already talked enough, I think, about debts. I think you're aware that you should not be giving any distributions to beneficiaries until you are quite comfortable that you have enough liquidity in the estate to pay all of the debts. The creditors will always take precedence over beneficiaries, and you don't want to be left with any personal liability if you failed to pay a creditor and you made a distribution to a beneficiary. You could potentially be held personally liable for that. Estate taxes, again, this is a twofold item. There is the federal estate tax exemption amount, and this is that number that you've probably heard, $5 million indexed for inflation. So if your estate is in excess of that, you're going to have to file an estate tax return for those amounts. You do also have to file the decedent's last income tax. So in the year in which they passed away, you have to file their last income tax return. And then the trust itself, once you take over as trustee and the grantor of that trust is deceased, the trust itself becomes a tax-paying entity, and you must actually get a tax identification number, and from that point forward, the trust will file returns for any income that it receives. So just from a planning perspective, we will usually try to dictate that the income that the trust is receiving would be passed directly out to the beneficiaries. Trusts are taxed at a much compressed bracket than individuals, at least currently. So we don't want to run into a situation where the trust is paying income taxes unless we absolutely can't help it. So you do need to, that's where having the CPA on board on your team is a good idea to make you aware of all of these issues and make sure you don't miss any deadlines. You also want to be sure that, and usually, not that they're ever fun to deal with, but the IRS will give you the information that you need once you alert them to the fact that you have a decedent involved and you are the properly authorized person. You can generally get information from the IRS. Safe deposit box, I know that many people are fond of these. They can be a catch-22 because the banks are particularly careful about not letting someone have access to a safe deposit box unless they are named on the account holder's account that person has the ability to access. So that can be tricky sometimes, but you want to just take the same level of proof that you have taken to your other institutions that you are a successor trustee. But oftentimes, if there is the existence of a safe deposit box, it is an often overlooked asset that sometimes will have to run through the probate process because the person forgot to make sure that the trustee would have access to this. Lawsuits are another item that falls into your bailiwick as trustee. If the decedent passed away in some sort of an accident or there's some other wrongful death type of situation related to the death, it would be the trustee then who takes on that affirmative role to bring an action. Also, if there were any actions against the decedent, they do not go away just because the person passed away. If there is an obligation there, it will be an obligation of the estate, so you may get pulled into litigation as a trustee because of actions that were already pending. If the decedent was a small business owner, this can get very complex, and hopefully you have discussed this with the grantor if there's any need for you to make immediate actions to make sure that the continuation of the business is not interrupted because of the death. This is also, again, often overlooked with small business owners. There's really a great succession plan, and you want to do your best as trustee to preserve the value in that business. We've already talked enough about insurance. I already alluded to the fact that you need to ascertain your liquidity needs and make sure that you pay things in the order that is required. And remember those creditors, and you will often have very demanding beneficiaries, but take your time, do it right. You have much less chance of having liability for being slightly slow. You can't drag your feet forever, but being slightly slow in a distribution to make sure you have your ducks in a row is always the better choice than making some distributions and possibly holding personal liability. So that was a lot of ground to cover, and there's much more depth that we could go into in any number of those topics, but hopefully this has at least given you an idea of the level of responsibility that's required of a trustee, and it will help you either in serving as a trustee or in considering who you think is appropriate to serve in your own estate. And I think we're going to open that up to questions.
Okay. Well, thank you, Autumn. And yes, we are going to open it up for questions now. And I am about to provide you again with Christy's email here in a second. If you could please direct your questions to cwhite@ebw.com, we would appreciate it. Okay, so while we get some of the questions, I do have another question, or actually an explanation. Autumn, if you could, I know that many a times we've gone over some of this information with our clients and told them what it is to fund a trust. Could you define that for the clients, please?
Sure. So I most often get approached by people to actually draft and create their documents, which might include a trust. That might be the most appropriate vehicle for them because they don't want to send things through probate, or they have family dynamics that make trust the viable choice. Well, very unfortunately, we oftentimes see people take that step. It's enough of a step that people don't want to deal with in the first place, that once they've done that and they've got the documents drafted, they feel like they're finished and they walk away. In order for a trust to actually do its job seamlessly, we want, once that trust is created, we then want to fund the trust by actually transferring all of the assets that you own in your individual name into your name as trustee of your own trust. So that would be, for real estate, you would actually record a new deed that transfers it from the individual to the trustee. For brokerages, you would fill out their paperwork, and each institution has its own paperwork. Much of this can be done online now, but it's either online or with printed forms where you would authorize the account to go out of your individual name and into your name as trustee of the trust. We'll always include the date on which that trust was signed as part of the actual name of the trust. Because one interesting thing about trust is, unlike wills, you can have as many trusts as you want, and a later in time trust does not necessarily supersede an earlier in time trust. So wills, that's the case. If you wrote a will today and you wrote a will 5 years from today, the 5 years from today will is always going to supersede today's will. The trust, however, you draft a trust today, unless your later in time trust specifically revokes that earlier trust, both trusts could be in existence. 2 trusts, 3 trusts, 4 trusts. And you will see this happen where people, usually I believe it to be unwitting, will have multiple trusts out there. So when you're funding a trust, that's why we always refer to the date on which it was signed, so that we hopefully understand which trust provisions are governing those assets. Trusts only govern assets that they own. So that's a hugely important piece of the puzzle and part of the process once a trust is drafted, to actually get those assets in there during lifetime. If that does not occur and you end up in the situation that I mentioned where you have a perfectly well-drafted trust, but it doesn't have any assets in it, all those assets are going to run through probate, and after they get through the probate process, they'll be gifted to the trust, and the provisions of that trust would still govern. You would still be doing the same distributions that you would otherwise have been doing, but you just have to run through a probate process first, and we would hopefully put it with you.
Okay. And we have another question here. What are the pros and cons of using a private third-party trustee, such as a bank, a trust company, an attorney, or an accountant?
I'm viewing that as sort of a two-part question. The first part is I refer to sort of a spectrum of trustees. You've got friends and family members at one end of the spectrum, and you've got bank trust departments and standalone trust companies on the other end of the spectrum. I would put your attorney and CPA, what I refer to as a professional trustee, in the middle of that spectrum. And the differences between the two is going to be proficiency in dealing with the responsibilities, and also costs. So as you move up the spectrum, the costs are going to increase. So the standalone trust company or bank trust department is going to incur the most fees for trustee services, and there will be fees incurred if you use a professional trustee as well. So that would be a con for those two. Generally, friends and family members, they may take slight compensation, but generally not on the same level as a third party. So cost is generally seen as the main con for an outside third party. The tremendous pro is the person or institution is very well versed in doing this. So they've done it before, they've done it, hopefully lots, and they have encountered some of the challenges that inevitably come up. They know how to deal with them. They proceed on accordingly. Another big pro is the lack of emotional involvement. So you have somebody who's really just looking at the terms of the trust and is trying to honor those terms with much less emotional involvement, and that can play both ways. So you could have it that you want that disengagement with your beneficiaries. That outside person is much less susceptible to persuasion than a friend or family member, and it may just be that it's too much of a burden on a friend and family member to put them in that position. So I see this actually a lot of times with siblings, where one sibling is named as the trustee and the other siblings are beneficiaries, and it has a tendency to destroy the relationship. So unless you have a very clear understanding of the family dynamic, the third party can often be the easiest route to go from an emotional standpoint.
And a follow-up to that question is, what are the costs with regards to these different types of trustees that you can obtain?
Okay. The cost of a professional trustee is generally everyone that I've run into, and you could run into something different, it would be upfront. They would have to disclose what their fees are going to be upfront. But generally, for either the CPA or the attorney, it's going to be their normal hourly rate.
Okay.
And for effort, it depends greatly on the complexity of the trust assets and what's being required of them as to how much time that eventual bill will be. The trust company or trust department of the bank will generally charge a percentage of the assets being managed, and then they may also charge additional fees for specific tasks. So usually a trust company, they charge their percentage of assets managed, and then if they have to do anything with real estate, that will all be separate charges. Not as easily in their bailiwick. So what they publish a fee, every institution publishes a fee schedule, and generally somewhere in the range of 1.5% to 2% that they'll charge as their base fee.
Okay. All right, there's a continuation to this question, which is actually a very good question too. What happens with firms that go out of business? Attorneys may retire, accountants may retire, or they go out of business, or the trust company may go out of business. What happens in those situations if they're named as trustees?
So the trust company, so this may also be seen as a big pro for a trust company. So a trust company who is named as a trustee, provided they are aware that they were named as trustees. So you want to make sure that if you're in the planning phase, that you actually have run that trust past the institution that you're naming. If you're naming a trust company or a trust department, you want to run that in the drafting stage. You want to run that past the institution. They will usually have some required language that they want to have in the trust before they would accept the trusteeship. And then once it's signed, you would actually have a copy filed with that institution. So provided they have been made aware of the fact that they're a named trustee, if they get sold or go out of business, they have an obligation to let you know and to give you an opportunity to reassign that to someone else. They will usually suggest their own successor. You can either go with their suggestion or go your own direction, but they have that obligation. Similar with attorneys, as far as attorney who retires, if an attorney retires or goes out of the practice of law, there is an obligation of notification. Obviously, if you have a solo practitioner who passes away, the chances of you receiving that notification are less than if that attorney was with a firm. So the obligation of notification runs to the firm. So if the firm has an attorney who retires or passes away, the firm itself would reach out to those clients that may be affected by that retirement or that passing away. So a larger firm will have a little bit better continuity, and then usually they would have someone within the firm that could take over if you've named an individual attorney.
Okay. And another question that was asked is, what about if they do their trusts here in Virginia, Maryland, or DC, and then they move out of state when they retire? What happens to their trust?
Okay. So first thing to be aware of is that it is not automatically invalidated just because you've crossed state lines. So particularly with trust, that the statutes, the Virginia statutes that I referred to early on in the talk, what it actually is, we have a body that creates what we call uniform codes. So this body puts forth a uniform law, and it gets sent out to all of the
Autumn, could you get closer to the speaker? You're fading out.
Oh, sorry.
There you go.
So you have this uniform law, and the states have the ability to adopt it or not adopt it, or to adopt it with some changes. So many, many, many states have adopted what we call the Uniform Trust Code, including Virginia. There will be slight differences between the provisions from state to state, but when you're talking about a uniform law, the whole idea of uniform laws is to have some continuity between states. So most trusts will be absolutely fine as you move from state to state to state to state. The only caveat to that is that we've got 9 states on the West Coast, or on the western side of our country, that are what we call community property states. They have an overarching law that is quite different from the overarching law of the remainder of the states. So you might have provisions in your trust that are contrary to community property law, and that would be the only time that you may have to take a look and make sure that you're you don't have provisions in your trust that are contrary to that sort of main law. Easier to come from the west to the east. It's less restrictive as you come out of the community property states, but if you're going to a community property state, you probably should have it looked at.
Okay. And the last question that we'll take for today, it says that basically it looks like the trustee does a lot of work in many cases. I guess it depends on the size of your assets. But in those cases, does the trustee get paid? Is there a provision within the trust that allows the trustee to be paid if they're not one of the beneficiaries?
Yes, and the document itself governs the payment. So it can range anything from reasonable compensation to an actual dollar or percentage amount, and that just depends on the grantor, what their desire is to pay the trustee. I can tell you when I'm advising clients, I do always advise them that if you are naming a friend or family member, you really do want to compensate them. It's a huge job, and you want to incentivize them to do a good job. So reasonable compensation usually is some percentage of the assets involved, and we have statutes to deal with that. So if the document says reasonable compensation, we would look to the statute for our guidance on what those amounts should be. And like I say, it could be that the grantor themselves puts in a percentage or a dollar amount.
Okay, well, Autumn, thank you so much for your time, and I want to thank all our attendees. If you have any further questions with regards to estate planning, I would suggest that you contact Idalis or one of their associates to set up some time to discuss some of these issues with your advisor. So in the meantime, know that we will continue to have webinars next year. We will hold 4. The first webinar that will come up in January will be an economic outlook to the markets and our economy for 2018. So that will be the first quarter webinar that we will have. Again, thank you for your attendance, and we hope that you've enjoyed this presentation.
Thank you all.